Hello? Hi. Okay, how do you find it? For Ruggenrud?
Ron Rude.
Ron Rude?
Yes, sir.
Okay, thank you. Ron Rude versus Hartnett.
Good afternoon. Ruben Dupay here on behalf of James Ron Rude, the appellant, former husband in this action. I'd like to reserve 4 minutes for rebuttal.
Sure.
The appellant in this case requests this court to reverse the entire order enforcing marital settlement agreement as it was entered following an unreasonable delay of 10 months and 12 days from the trial till the entry of the order, coupled with numerous findings that are either not supported by or are contradicted by the record. That those plus other factors and circumstances have created an unmistakable appearance that this order does not reflect the judge's independent judicial decision making. The first issue set forth in the initial brief sets out all the numerous factual findings which we are contesting, which the former husband does not believe are supported by the record. When I prepared for this oral argument, the piece that really kind of jumped out to me that in clarity that I don't believe the court got is really found within the the deposition transcript testimony of one John Holdsworth. He was working for the Collier County zoning office, and he was the one that received the lot split application and responded to it on 2 occasions. He set forth, and there was also trial testimony of a Ray Bellows, who was also in the county office, a different division. Pardon me for forgetting the name of it. But both of them talked about the 3 different manners in which the lot split could be accomplished. 3 specific manners. One would be, obviously, there's a Quonset hut on an agricultural piece of property of 5 acres. The 5 acres was met, but the Quonset hut isn't a dwelling. It's an accessory structure. And you can't have a property without a dwelling that has an accessory structure. So the first option in the first letter of rejection said, tear down the Quonset hut. Then we just have vacant land, then we can approve the lot split. So that's one option. The second option is, which was given in the second letter, was if the Quonset hut itself has a bona fide agricultural use, the use of the hut in combination with a bona fide agricultural use of the property, it could be allowed to stay as an accessory structure because it was had a bona fide agricultural use. The property appraiser's office, tax appraiser's office, would send an inspector out to the property to inspect, to verify that there was a bona fide agricultural use on the property and that the Quonset hut was in compliance with using to assist that.
That exemption had applied previously, correct? Because of the wife's horses on the property?
That exemption wasn't necessary previously.
The home.
Because the one parcel had the home. In fact, Mr. Ron Rude never used that Quonset hut for anything other than storage for his business materials.
Let's come down to it, though. What difference does it make as between your client and Ms. Hartnett? You expressed some concern in the brief that the judge shouldn't have found that it was his fault. What difference does it make? He has an obligation to accomplish it.
Well, they both
under the contract.
They both under the contract had the obligation to accomplish it.
She filed the application. She doesn't have the right to take down or construct anything on property that has been awarded to your client under the marital settlement agreement.
Correct.
Right? So it's to him. How in the world can she do anything other than sit back and insist that he comply with the agreement in some way?
I don't disagree with that, but I challenged Ms. Hartnett in cross-examination to show me and to show the court what specific provisions in the agreement has he not complied with, because nowhere in the agreement did he agree to raise the hut, to destroy it. Nowhere in the agreement did he agree to make a building, or nowhere in the agreement did he promise he would use the hut or the property.
It has to be split.
It has to be split.
That wasn't the agreement, right?
The agreement was to split it, and
she cannot do anything to accomplish the split. It's only him.
Correct. And his testimony was he was diligently working to build a dwelling that was the option he wanted.
That was option 3. I have a question about option 3. I believe your opposing counsel, I want to speak for them, is going to say that regardless of whether he accomplished option 1, 2, or 3, it is still incompatible with the use of the Quonset hut for his business, and so it wouldn't matter.
And that's the point of clarity that came to me, is that argument being made by the former wife. I thought it was obvious when I took the deposition of John Holdsworth. He specifically says under option 3, the bona fide use we talked about with option 2 doesn't exist with option 3. If he has a dwelling, he can use the accessory hut for whatever purposes he wants, as long as it doesn't, violate code. But there's no evidence that Mr. Ronrud's current use of it ever violated code. There's no evidence that his current use, which is consistent.
But the argument is that his current use of it, which is for his business, is incompatible, forecloses his ability to get.
But the county, that was the argument, but the county never testified to that.
I suppose. Say the scenario would be that you build a house, your client builds a residence that is then sufficient to accomplish the split, whether the use of the Quonset hut for a commercial purpose violates, some sort of ordinance or code, then becomes a separate issue between your client and the county, correct? I mean, they could say, you got to stop using it for that.
Yes, sir. That would be a code.
They might have approved the split.
Yes, sir. Because, and it's Mr. Holdsworth's testimony, his deposition testimony, which wasn't even referenced in the order, specifies that as long as it can be tied to the residential use of the house, it can be tied to any use whatsoever, as long as there's a dwelling. My rationale, and I don't know if I learned this somewhere, just assumed it by implication. The reason for that is they don't want people living in an accessory structure that's not up to code. If you're going to live on the property you have a farm on, you better have a dwelling that's up to code. We don't want you using it.
But so tell me
Can't sleep in the barn.
what is wrong. What is wrong with the judgment? It only gave him 2 of the 3 options. Is that what you're saying?
Well, the judgment is wrong because 1, it's ordering specific performance for something that's not specifically set out. It's ordering him to do one of the 2 options.
It's ordering him to do one of the things that the evidence says he has to do in order to accomplish the split, which is required under the agreement.
Correct. But it's ordering it in a very specific, it's ordering a private person to do something very specific with their own real estate that isn't in part of the agreement.
If he built the residence, came into compliance, and got the split, and what you're saying is that would not foreclose that the commercial use of the Quonset wouldn't foreclose that. That would be a subsequent issue between he.
That's me off the top of my head. I don't know that the evidence says that.
Mr. Bella's testimony was that there are certain things related to a person's business that you can use your house for. He talked about home office. He talked about storage. I asked him specifically in cross-examination, can he store things for his business there? Yes, as long as there's no advertising, he's not bringing customers out.
Assuming for the sake of discussion that the use of the Quonset hut for the business did not foreclose the possibility of getting the split. If your client were to build the residence and obtain the split, would your client be in violation of the order now on appeal because he didn't
One of the other 2 things.
raise the hut?
Right.
I don't know, perhaps.
Why? Why?
It depends
Why would
on-
he not be in compliance?
I'm sorry?
You said perhaps. If he chose option 3, obtain the split required of the MSA, would he be in compliance with the order on appeal?
I don't know, because there were 2 orders entered and they were both identical, with the one had a handwritten change that said or build a unit. That was the first order that the judge signed. And then the judge entered a second order, nunc pro tunc, to an earlier date without the handwritten change.
Yeah.
So I don't know.
I think you need to answer this question if you want us to consider reversal. Could he do what he wants to do, build a residence, which would enable him to get the split, and would he then be out of compliance with the order on appeal?
That's correct.
He would. Why? Why would he not be?
Because he was told to do one of two things, and if he exercised
Well,
the third option,
depends on which version of the order you're talking about.
correct.
And you're concerned that it requires him to do one of the options.
I'm concerned it requires a private individual to tear down a hut when he didn't agree to ever tear down the hut. The only reason.
Well, no, what he did do is agree to the split.
Correct. And he also testified in court that he was actively trying to accomplish the split. That was, I made a metaphor, it might be poor, I've used it before just colloquially of, it's like suing for the sun to come up tomorrow. The sun's coming up tomorrow whether we want it to or not. I don't need an order to do the things. He went to court and said, I'm trying to accomplish this. I've paid for my plans. I've done this. I'm going to get a permit. And Holdsworth's testimony also clarified once that permit is applied for, the county could split the property then, allow him to, because they couldn't approve the permit when there's already a dwelling on the property. They'd have to split the property first to allow the permit in the building to go forward.
So if the operative judgment is the one with the judge's handwritten addition,
Correct.
then that works for your client, correct?
Yes,
To build the dwelling.
I'm looking for, yes, the handwritten or build a structure that complies at husband's expense.
Right.
That was a February 3rd order.
At that point, you would be fine. You'd be in compliance with the judgment, and the judgment would not require anything other than what he's trying to do.
Yes, sir. We haven't talked about the Kubota tractor. I don't know if the court's ready to move on to that subject or not.
It's your argument. Have at it.
Well, actually, first I want to talk about the other issues I'm concerned about in the unreasonable delay. Obviously, there was the passage of time. There were what I believe, what we've asserted as numerous factual errors in the order, a logical disconnect between some of the legal conclusions raised. As it relates to the tractor, for example, one of the findings specifically acknowledged that the Kubota tractor is not mentioned in the marital settlement agreement. And if it's not mentioned in the marital settlement agreement itself, by logic, dictates that it didn't do anything with respect to the Kubota. Yet there's another finding, and then I think even a legal conclusion, that the marital settlement agreement gave the Kubota to the former wife, which if it's not mentioned, how I don't see any connection.
Obviously, the judge was looking at the paragraph of the marital settlement agreement that said, other than these other things that specific that we've mentioned, we've divided everything up and we're happy with it. So the evidence, then the evidentiary question was what was the evidence about the Kubota?
Yes. There was no evidence provided about any other agreement, any prior agreement that predated the marital settlement agreement about ownership of the Kubota.
Did your client have any property out of this marriage that was never specifically agreed to?
I don't know.
I think that kind of provision is not uncommon in these agreements,
That
And so,
provision is
like if I've got the china that was given to us for our wedding, and it's not mentioned in the agreement, but it says we've divided things up already and we're happy with it, pretty much that china's going to be mine, is it not?
agreed, but usually that provision also talks about property already in the possession or control of a party.
Well, and was not there was indeed evidence that this Kubota was in Ms. Hartnett's possession and control.
Certainly. Sure, it was on the property that was being given to her.
So you're only concerned then in terms of whether there was error in that regard would have been the passage of time and the signing of the judgment submitted by Ms. Hartnett. Because I think you acknowledge that there is competent substantial evidence that Ms. Hartnett was in possession of the
Right, but
your client would disagree about some details, but there was competent substantial evidence to support that determination.
Sure, but my point is that the settlement agreement doesn't raise possession as an issue. It just says we have already entered agreements. It doesn't say, and I keep everything that's in my possession, you keep everything that's your possession. It's missing that language, and because it's missing that language, it just says everything else was already divided by agreement.
So by what right did your client sell it?
He believed it to be his, he believed it
On
to,
what basis?
because the settlement agreement says that he's keeping his business and he's keeping,
But he didn't sell it as part of his business. He sold it individually.
I disagree with that. There's no,
Well, that's what the receipt or the bill of sale says.
there was no receipt. It just said he, yeah, he
There's a
said,
document that says I, Don,
John,
not as president or owner of this corporation.
sure, the handwritten, yes, the
Yeah.
handwritten bill of sale between two, you know,
Bill of sale, seller,
receipt, whatever you want to call
right.
it.
So in your view, rather than moving to get it by enforcing the marital settle agreement, she should have filed suit for conversion?
No, she did file suit for conversion. In my view, she got a judgment under conversion and she failed to prove that she was the proper owner of the property entitled to damages. She failed on the first element, or the element that she owned the property to start with. Because either, the judge also made a finding that it belonged to the two of them.
Yeah,
So our position, the former husband's position, was that it belonged to the business first. Former wife's position, or the judge found it belonged to the two of them first, and then the marital settlement agreement gave it to the wife. I don't believe the marital settlement agreement gives her anything, and there's been no evidence of any prior agreement that gave her anything. Therefore, if it wasn't divided in the divorce, it would remain owned by the two of them. So,
except as otherwise agreed to above, the remaining personal property has been divided equitably between the parties, and each acknowledges that they consider said division to be fair, and each acknowledges his or her satisfaction with such division.
correct.
And I think the evidence was, or her view was, it was her tractor. She picked it out, left at her place. You know, he would borrow it, you know, but otherwise she had it. She had the key, and it was hers.
Yes, sir. That was,
We're at 4 minutes left, Mr.
Okay.
Day. You can use them as you please.
thank you. I'll take it for rebuttal then.
Okay, great.
May it please the court, Thomas Franchino, and I represent the former wife, the appellee. I'd just like to point out a few dates that this is an order being appealed that enforces a marital settlement agreement. The marital settlement agreement was entered into 12/6/2012, December 6, 2012. And the day-long evidentiary hearing on the motions to enforce that marital settlement agreement. And also there was a counter petition for partition and asking that the former wife be forced to pay for half the cost of building a residence on the former husband's 5-acre. Didn't take place until April 3rd, 2018. And of course, here we are 7 years and approximately 9 months after the marital settlement agreement was entered into. And there's really no basis for this appeal because the record, as I hopefully pointed out in my statement of the facts, contains ample factual basis to support the judge's order. She heard that evidence at a day-long evidentiary hearing. She saw the witnesses' credibility, and her judgment must be affirmed. But I'm going to go reverse order on the tractor. And Your Honor is right. The tractor, the testimony, and this is the former husband's testimony, so I don't know what the dispute is, was that they picked out, actually the former wife picked out that tractor as she needed it for her horse operation, or horse ranch, I call it. I don't know if that's the proper term. And she used it almost exclusively. She said he's used it 3 times over the years. He testified, I might have used it a handful of times. So over 10 years, he used it 5 times to mow some lots located somewhere. Was never used by his business. And here's the important facts. He had vacated that farm, that horse ranch, 2 years prior to the MSA being entered. So at the time of the MSA, he hadn't been there where the tractor was located for 2 years. At the time of the MSA, the tractor was sitting there being used on the horse ranch. And as the judge says, the provision is the remaining personal property has been divided equitably. And well, I'm leaving out a few words, divided equitably, and each acknowledges the division to be fair. So there's a real life division of the property. And then he testified that 2 years after the MSA, again, that the properties remain there at the horse ranch. And then in 2014, at some time, he asked the former wife to borrow the tractor. I think that fact alone is enough to support the judge's conclusion. The former husband wouldn't be asking to borrow a piece of property if he had the right to, if it was owned by him or his business. And then, as Judge pointed out, he received a receipt, a bill of sale saying, I, James Ronroot, sell the 10,000, and he testified that was accurate. So there's no doubt. The only issue they raised, well, they raised some issue about the key, but I don't know how that's relevant. But they say that the business paid for it. But again, the former husband testified and the former wife testified that through their business, they bought almost everything through that business. They paid for cars through that business, boat docking, 2 lots that the husband was awarded upon the divorce in a different location were bought by the business. And even this horse ranch, this 18.6 something acre ranch, was paid for by the business. So the payment means nothing. There was no title, and the actual history of the parties and the facts demonstrate it was used exclusively for the horses, and that's where it was when the MSA was. Now, maybe I could clear up some confusion with the Quonset hut. The Quonset hut was on the 5 acres, and the former wife initially had to hire an appraiser, a surveyor, to come up with a meets and bounds lines so they could create a separate lot and apply to Collier County, because the Collier County had approved the lot split before. It would be 2 separate lots with 2 addresses and 2 utility accounts, etc., 2 tax statements. And she did that. And the county's response was, you have a Quonset hut on a vacant piece of property, that's not allowed. You have to tear down the Quonset hut. And the husband testified at the trial, at the hearing, that he wouldn't do that because it was an asset of his business. And he testified that it was, quote, primary area to store my business equipment and forms. And later on, he testified that the Quonset hut, quote, was 3/4 of the way full with business equipment and forms. And he testified that every piece of equipment not necessary for a job, along with the concrete forms, were kept in the Quonset hut. So there's no doubt that that was his housing, his business operation, is a construction company, a concrete company. So he wouldn't tear it down, he testified. Now, some years later, this case dragged on for a long time. In 2017, the initial application had run out, was termed out, and they had to reapply. And now the county said, you can keep it, but you have to give us a bona fide agricultural use. This property was zoned agricultural. He took it as agricultural. So the fact that he might have been using it as a business use illegally doesn't mean that somehow he has some vested rights. It was zoned agricultural, and the county people said there's no way they would approve a lot split if that was a non-agricultural use, if he was operating his business out of it. So
if he had a home on it.
But still, even then, the zoning director for Collier County was quite clear. If you had a home on it, that was proper. You could build a home in a agricultural area, and you could keep the Quonset hut as a accessory structure, but it had to be a residential accessory structure. You couldn't operate your business out of it. He could keep his lawn, his tractors, and the equipment he needed. Basically, he could treat it like a large garage, but it had to be obviously something with the residents. Not. So
are you contending that based on that evidence, the trial court thought better of allowing him to build a residence? In other words, is that the explanation for the fact that the subsequent order did not include the handwritten portion? I
think the judge went along with his argument that if he built a residence, he could gain the lot split.
Okay, but I know, but so let's say we understand the court, what it sounds like you're saying, that understand the court was giving him the option to build a residence in order to obtain the split.
Correct.
If we assume that, should we just affirm and hope that the trial court enforces the order with the handwriting?
Well,
Or
I
do
think,
we reverse to clarify that since the subsequent order says it's, nunc pro tunc to a time prior to the previous order, that we have to resolve some sort of confusion about what the husband is permitted to do under the order?
I assumed, I just heard that argument now. I assumed the second, or let me put it this way. I assumed the order with the handwritten option in it was the second. And also that was,
I don't think it is. I'm not looking at the record, but I'm looking at notes.
No, it's not. It's the first one.
it's
And,
the
and,
first.
and the question I have though, and that's the one that's attached to the notice of appeal.
Exactly. That's the one.
When was the second, how long, much later was the second order entered? The first one was signed February 13th. And I don't see when it was recorded with the clerk. And I don't know, I can't right now lay my hands on the second order.
I can't either, Your Honor. But again, I thought that was the operative one because that's the one that's appealed from. And I mean, there's no, in my opinion, I'm not going to fight to say that the other order was the operative and the one with the handwriting isn't. But
well, if the first order was a final, unless the second order was actually the court sua sponte rehearing, well, the court didn't have any jurisdiction to enter the second order because it's already entered a final judgment. It loses jurisdiction at that point, except under certain situations like motion for rehearing. And, if the court, but generally you would expect the court to say it was granting rehearing, not just sign another judgment.
Yeah, well, and it happened so quick, there was never any request for a rehearing. We received the one order and then I think it was like the next day, the other order. So, and it's not a final judgment, it's an order enforcing marital settlement agreement. So maybe that's an interlocutory order that.
No, I think it's a final and appealable order. It's not like a money judgment, although he was ordered to pay her some money.
Yeah. So anyway, he had that option, which if followed and allowed the lot split, satisfies his obligations under the marital settlement agreement. And then the other thing the judge enforced, he owed her some money as she had to pay for the lot split process and the insurance and the taxes, and there were some other amounts. And then the $10,000 he received on the tractor. So those were all in that order enforcing the marital settlement agreement. And I think there's all support in the record. Obviously, there's findings of fact. There's only 9 that are picked out, but I think I showed in my brief that there's substantial facts for each of them. There's no confusion. And the fact that it took the court 10 months in and of itself should not cause a reversal. Again, the parties have been waiting, or my client's been waiting since 2012 to enforce that marital settlement agreement, and to allow any kind of delay at this point would only push it back even further. It'll be out 8 years and longer before she could get any relief from the court. So I would ask the court to affirm the judgment that was appealed from, and let the case go from there.
Okay, thank you, Mr. Franchino.
Thank you.
Mr. Dupay?
Yes, sir. Just because I have the benefit of having my computer, the second order was filed in the court file on February 26th.
Yeah, I see that now.
It was made, so I don't know when it was signed, but it was made nunc pro tunc to February 2nd, which technically predates the first order. So I don't know. There was no, to my knowledge, there was no communications with the judge asking for any change or anything. It was something the judge must.
Right. But there had been the first one in which the court wrote, on which the judge wrote, was filed on the 14th of February. So 12 days before the first.
Yes, sir.
And that's the one that you attached to your notice of appeal.
Yes, sir, because it was the first one entered.
Right.
And to be quite candid, I didn't recognize that there was a difference. When I got the second one, I thought it was the same one and
Gotcha.
filed. With regard to the unreasonable delay, I believe there's also an additional problem with how the order came about, and the appearance of confidence in the judicial system, at least with respect to Mr. Ronru. Certainly, the party that wins these things won't have any, will have plenty of confidence in the judicial system. But for 10 months to go by, for 6 months to go by, and then without invitation, an unsolicited proposed order is provided to the court by one side. And this is not a strict Perlow issue because we did have a chance to provide our own proposed final judgment. Both sides were able to provide final judgments. But then another 4 months went by with zero communication from the court, I think 4 months. And then the court just signed one of the orders one day. Oh, I believe the
Well, and the thing is that I understand your concern, and it's a long delay, and that's not good. But Perlow, it's not an automatic.
Yes, sir.
Right.
Correct.
And I have two thoughts about it. Number one, and I'm not sure what you would expect if we reversed it and remanded it. You're going to get probably the same result. But even if you don't, the fact that the judge wrote on the order she signed first, I think it was she, correct?
Yes.
And that was and based on your argument today, is acknowledged that was a substantial change. It added the third option for your client to accomplish the split. That was a significant alteration to that judgment. I think couldn't we look at that and say, we conclude that the judge exercised her judicial function, even though otherwise the judgment is the word for word judgment.
But yes, you could conclude that, sure.
I think if she had signed just the second judgment without the, adding to it, you would have a much stronger case on the Berg Perlow. Is that what it was called?
But what about the other findings that are equally, if she understood that?
Well, here's the thing though. One side submits a judgment based on findings of fact that support its view. Mm-hmm. The other side submits a judgment based on findings of fact that support its view. The findings are yay or nay, black or white, and she chooses the one that complies with, comports with her judgment and memory. What was wrong with that?
If that's what she did, nothing.
That's what she did. So, if she had remembered things or believed things as your side submitted, she would have signed your judgment.
Okay.
But she didn't. She signed the other one. So, and especially combined with the fact that she wrote on it and added to the, relief, it suggests to me that we can't really conclude that she didn't exercise her independent judicial, authority.
Okay. I would say I believe there to be numerous unsupported facts. I know they're all out. Yeah. I'm not going to go over. And I think that making findings are fine. Saying, okay, I'm going to determine her findings versus his findings is fine if it's supported. There's findings though that are unsupported, and if those are the reasons that she believed and entered a certain order, there was never any proof that his business.
Well, let me come back. I'm not sure that your client was entitled to any relief anyway on the split. Contract required the split. What was required of him was pretty clear in the evidence.
Correct, but there was a denial of the motion would put everyone in the same place they were already in. There's already a final judgment ordering them to comply. There was no deadline that he had failed to meet. There was no,
No, but I mean, when there's no time requirement, it has to be accomplished within a reasonable time, as your counsel has pointed out. Years and years have gone by and it still hasn't been done.
well, but
So
it
I'm,
was, and as a result of this, she's going to collect attorney's fees because of the prevailing party attorney's fees clause.
correct.
And the reason she prevailed is because the court ordered him to do what he was already actively doing. So he has to pay attorney's fees to be told, hey, keep doing what you're doing. Good job. And pay her fees for having me tell you what you're doing is going to be successful.
I get it. All right.
Frustrating position.
Well, I've helped you use your rebuttal time, Mr. Dupay.
I understand. I appreciate
Thank you both very much.
Thank you.
All right, we will move on now